actually a debate we've had within our own program as well.
Oh, really?
Like for SOAP notes and the
Yeah.
documentation we have.
Yeah. And it's fun. It's funny to see how much they write and how well they write. It's very interesting.
Absolutely. Very, very insightful. I think we're right around the 2 o'clock hour. So
Whenever you're ready.
go ahead and do the
Yep.
Good afternoon, everybody. Thank you for joining us for the first session of the afternoon following the awards luncheon. I hope everybody enjoyed your time at the awards luncheon and that you're ready to go for an afternoon of additional education sessions and retreats this afternoon and so on as well. This is session number F142. So if you find the yellow sheets of paper for evaluating the presentation sitting on the chairs around you, or if you would choose to evaluate the session using the app on your smartphone, it would be session F142 that we are about ready to enjoy. As long as you have your cell phone out, could you please silence it as well and make sure that we don't interrupt our speaker this afternoon. I do also want to make you all aware that this is one of the sessions that we will be recording for the opportunity of viewing it at a future time, so there will be a recording going on during the session as well. The title of our session this afternoon is Keeping a Tight Lip, Lecture Intellectual Property Policy, Opinions and Options. And I will turn it over to our presenter this afternoon. Thank you.
All right. Well, thank you for being here. I see that I have the enjoyable privilege of talking about a very boring subject after a very filling meal, and you're all sitting in the back behind the lights, and you're going to fall asleep, and I'm not going to be able to tell, but that's okay. I do thank you for the opportunity to come back and present this again at the request of the committee, and so it's a pleasure to be here. So let me introduce myself. My name is Jason Grahame. I am an associate professor at Eastern Virginia Medical School, as well as the director of admissions there. I have worked clinically in orthopedics since graduating from the program in 2003, and returned to be on faculty in 2007. And so I enjoy the process of educating students, and have always done so even while I was in class as a student. I have no financial disclosures to make. I receive no compensation from any of the programs that I'll talk about today. Or from any other industry for that matter. And I am not a lawyer. I have never played one on TV, never acted as one in a play, and did not stay at a Holiday Inn Express last night. So with that, let's move forward. So my goal today is to define for you define intellectual property and copyright in the context of PA education and what we do, how we provide lecture content, derive that, and develop it and deliver it to our students. I want to try to help you become familiar with some copyright laws and the fair use doctrine and in higher education, and identify some potential abuses of lecture content that you may be aware of or may not have thought of, and discuss some options for protecting your lecture intellectual property. So what is intellectual property? It is, by definition, distinct types of creations of the mind. Some have referred to it as imagination made real. It's when we take something of a conceptual nature in our mind and put it into some form. It is a discrete piece of material that is identifiable. It is the ownership of a dream, an idea, and an improvement and emotion that we can touch, see, hear, and feel. And when we talk about intellectual property, there are 4 broad concepts that are incorporated, or categories underneath of it. Patents, trademarks, copyright, and trade secrets. And where we're going to focus on today is more the copyright side of things as it relates to our lectures. Patents are pretty much a 20-year protection for useful purposes on machines and compositions such as medications and those things. And it might be a design for an article of manufacturing and some plant variety that it's typically awarded for. Trademarks are the words, the names, symbols, sounds, and even colors that distinguish goods and services. Copyright are the works of authorship, where we actually author some content. And trade secrets are the information kept in confidence that set one company apart from another, giving them some advantage, whether it's real or perceived, over their competitors. So when we talk about intellectual property, why do we even have it, or why is it even there? And for the objectives of having intellectual property by definition, or by some who promote this, one being the World Intellectual Property Organization, suggests that it provides some financial incentive for a company to have, or for an individual to have, intellectual property. There in their handbook promoted as a deliberate, they promote as a deliberate act of government policies and creativity in the dissemination and application of results to encourage fair trading, which should contribute to economic and social development. The anti-counterfeiting trade agreement also suggests that this actually helps maintain economic growth, suggesting that the effective enforcement of intellectual property rights is critical to sustaining economic growth. And interestingly enough, 2/3 of the value of large businesses, according to some studies, in the United States can be traced to their intangible assets. There's also some arguments that are made from a morality standpoint. Locke suggested that there are natural rights and justice, that we should be able to protect our own intellectual property. A person has a natural right over the labor and products produced by their body, or in that case, their mind. Appropriating these products and misusing another's ideas would be considered to be unjust, according to Locke's arguments. There's also a utilitarian and pragmatic idea that society that protects private property tends to do better economically than other countries. Many would attribute the 19th century innovation and invention in America to be due to the same time as the development of the patent, and without this protection there would be a lack of incentive to promote these new ideas, and that protecting IP, or intellectual property, helps optimize social utility. Hegel would argue that personality, it's an extension of who you are, that every man has the right to turn his will upon a thing and to make that thing an object of his will. That is to say, to set aside the mere thing and to recreate it as his own. And he would suggest that an idea, or something that you create, is something that's an extension of you, and one that we should respect. Even Ayn Rand, in some of her writings, suggests that protection of intellectual property is essentially a moral issue, where this emerges from the belief that the human mind is the source of all wealth and survival, and that all property at its base is intellectual property. To violate that is not different than the other property rights, which comprises the process of survival and constitutes such an immoral act. So there have been some arguments for and against intellectual property. However, let's go to the real nuts and bolts of why we're here. Why should we even discuss it? And my question is, how much time do you spend creating creating your own lecture, the expression in some tangible form of the material that you're presenting to your students? How much time does it take you to recreate, or to take that information and massage it into a lecture? How long does it take you to update your lectures and those things? And for me, I find it to be quite a bit of time. And maybe I'm just not as good at it as some other people, but it certainly does take an immense amount of time. And then my thought is, how do we distribute this to our students? How easily do we give this information away in the time that we invest? And the real impetus behind this lecture came about 3 years ago when our program decided to go paperless. We were moving into a new building, the budget was being confined in some ways, and we wanted to become technologically savvy. And so the impetus to this was, we're going to have every student have computers and everything's going to be electronic, we're going to get rid of some of our printing budget, and let's see if we can't do this. Well, what became the modus operandi for our program was to just, instead of printing off notes from PowerPoint for the students to take notes on, we now just distributed to them the PowerPoint itself. And in my own thinking, I felt a little bit had some difficulty with that, just because this is what was the product of the amount of time that I spent working. So with the increasing number of PA programs and the students that we are teaching, my question became, how long before we see the recycled lecture? Taking one person's product and adding your name to it and representing it in another format. Or what about note-taking services? Probably not yet to be a concern for most of our programs, but even within our program, students from one cohort sharing their notes with another cohort, and how do we deal with that, and how do we think through that? Even some of my own colleagues have seen some of their own data, specifically their data actually presented at conferences. Others have seen their own lecture slides presented at other conferences. And I've even heard other anecdotal evidence of this from other people. Now that certainly is a professionalism issue, but are we adding to the ease of that with how we're distributing things? And then from the note-taking services side of things, there are a lot of sites out there that will actually post for use notes and will actually charge for them, and you get a kickback from those notes. It used to be a lot bigger of a problem in larger classes, obviously with general education and undergraduate classes, where they would pay somebody to go to class for them and take the notes, and then they would just distribute those notes for a fee. And so, again, that's some of the questions that were brewing in my mind. But in reality, this was a way for me to decide how am I going to protect the material that I'm investing my time and effort into from simply being easily cannibalizable. So what is copyright? This is a form of protection for what's considered to be original works of authorship. And those authorship works have to be fixed in some tangible form of expression. This protection is not unlimited in its scope. It's not something that is, you throw the copyright on there and you've got all the protection you would need. There are limitations to this. If you look at the original copyright law, and again, there are a lot of pages to it, so it's probably not something you're going to sit down and read easily. But sections 107 to sections 102 are the exclusions to the protections given to an author in 106. And so there are a number of things that this protection offers, but it's not unlimited. And the protection begins once it's fixed, once it's put into some medium that is not easily or that can be transferable. That's when you have copyright protection. It's interesting that in differences from 1906's first Copyright Act to the 1976 Copyright Act is that it no longer has to be considered published. You didn't have to actually take it somewhere and get a publication of it to actually afford this copyright protection. It's now offered as of 1976 across the board as soon as it's put into some tangible medium. And the fixation need not be directly perceptible. So I can't see electrons or on a cassette tape or the inscriptions on a CD for me to actually be able to know that it's copyrighted. But even though it's on some form of medium, I know it's copyrighted. And again, if I communicate it through the aid of a CD player or something else, or even through a video streamer, then it has copyright protection. So again, publication is no longer necessary. It's not like it has to be in a journal. It does not have to be at a particular institution for that. So the author's exclusive right, according to Section 106, is that you as the author have the ability to reproduce your own work. You can actually take that work and reproduce it in as many times as you want to. You're also given the ability to prepare derivative works. You can take those works and actually recreate it and reformat it into something derivative from that. And then you can distribute those copies or phonorecords by transfer or ownership. And this is done either through sale or by rental, lease, or lending. And you're also, fourthly, given the opportunity to publicly actually display this work, to perform the work if it's some type of a performance, or broadcast the work to those in the general public. I want to grab my notes here real quick because I can't see the mouse. So who is the author? This is the question that is oftentimes asked of who actually is the author of a particular work. Is it the employer or is it the employee? And according to the Copyright Act, it is basically looking at who is the one who is defining what the work is going to do. So as an author, if you're the one that gets to direct the work as you want to see it come out, then you are the one who has the authorship. However, if you were hired to make a work, if they came to you and said, I want you to create a lecture that deals with this for our particular institution, then it's considered to be a work for hire. And I'll get a little bit more into that in just a little bit. So work made for hire is work prepared within the scope of an employment, but it has to have, or it's specifically ordered or commissioned for use, and the parties have to expressly agree that it's a work made for hire. So just because you're an employee of an institution doesn't mean that you give up the rights to your copyright unless it's something outside of the normal bounds of your contractual agreement. So what are the protected categories? Well, it covers a whole host of literary works, musical works, and the words that go along with it, dramatic works and the music scores that go with it, pantomimes and even choreographed works, pictorial, graphic, sculptural works, motion pictures, audio visuals, sound recordings, and architectural works. But these categories are not to be specifically hardline categories, because you could see that a computer program would not necessarily fall into one of these categories discretely, and some would actually consider it to be part of a literary work. So again, there's a little bit of room for negotiation as to what are the categories and where does it fall. What is not protected? Well, what's not protected are unfixed works. And these, by definition, according to the copyright law, is that they're improvised speeches not written down. So if I walk up here without any notes and just did this off the cuff, so to speak, which in reality, according to a history lesson I just learned, that's actually writing off the cuff is actually written on the cuff. So it's really not, that's even still copyrighted probably. But if I were to get up here and just completely talk without any prepared notes, then that would potentially be not copyrightable. Or if I did a choreograph, which I won't, without any previously written down ideas of what I was going to do, then that would not necessarily be copyrighted. Works of the federal government or of government agencies are typically not considered copyright. That comes from a public data set, and so oftentimes that information is allowed to be used without any copyright contingencies. Titles, names, phrases, slogans, symbols, or design are not necessarily copyrighted but are trademarked, and so that's something that's a little bit different, still intellectual property, but a different category. The ideas, procedures, methods, systems, processes, concepts, principles, and discoveries or devices are also not considered to be conceptual or not considered to be copyright. However, if somebody describes in a written form what that looks like, that particular work would be copyrighted. So again, and then things that are in common property. Calendars are not copyrighted. Height and weight charts are not copyrighted. Tape measures, rulers, lists, or tables. Anything taken from public documents or common sources are not considered to be common property and not copyrighted. But even still, common property is not defined in its own document in the copyright law. They also mention what's in the public domain, and just be aware the public domain is not a location. It's not some place that you can just go, and if the public is there, that it's considered public domain. So just finding things in a Google search or in some place like that would not be considered public domain. What it is those works that are no longer under copyright protection. They either don't meet the requirements for copyright or their copyright has expired. And that's determined by the date in which it was fixed in its form. And in 1976, what they decided was that works prior to 1923 would have a 90-year limit on them. So we just passed that. So anything that you find from before 1923, if it's still able to be used, it's fair game. No more copyright protection. After January 1st of 1978, it was basically based off the death of the author. If there was one author, it was after his death plus 70 years. If there were two authors, whoever the last author to die, plus 70 years. And then if it was a made-for-hire document, it was the shorter of either 95 years from publication and then 125 years from its creation, again, depending on if it was actually publicized as a publication. Now, the fair use doctrine came about as a statutory exception because what they found was they were concerned that the rights, free speech rights would be impinged by having somebody's copyright. And so what they did was in Section 107 give a statutory exception. You were able to use without permission and to contribute to public discourse. You could actually cite somebody's work or use that work and actually maybe make a commentary about it or a rebuttal against it, as long as there was no significant harm to the author. And what they allow for was you to use a work as long as you considered 4 different things. And you may have heard of these before. The purpose and character of the use. Is it commentary? Is it criticism? Is it news reporting? We didn't want to infringe on their rights. Is it scholarly work or research that you're using this for? Is it parody? Is it historical timeline, web indexing? Is it for-profit or not-for-profit? And then the last question, is it educational or commercial? And if in the educational setting, we have a lot more latitude to use certain materials in our lectures and in other things for this. The nature of the protected work, is it actually publicized or not? Is it a factual work or not? How available is it to the public? Because that can infringe on somebody's ability to make money and to be able to have an effect on the market, which is the 4th thing. And again, how much of the work are you using? You can't assign War and Peace to a class and use the whole text and just say, well, we're going to use the text and not require anybody to purchase it. I don't think War and Peace is over 1923, but I could be wrong on that. But my point is, you have to use a small portion of it, and they don't define how much. They don't give you a specific amount. They just say that less is better, and that's where we come into some discussion as well. And then the last thing is, what's the effect on the market? If this information is solely held by the copyright owner and not available to the public, and you release it to the public, you're potentially in violation, probably would be in violation of copyright law. But the key is that this is not always straightforward. We don't always have a clear-cut, four-step litmus test to decide whether or not something is copyrighted and whether or not we're violating it when we use it. It's more often situational. And so what we need to do is make sure that we acknowledge the copyright and follow that. Now, this was in 1976 when this came about. Well, you can imagine that over the 1980s and 1990s into the 2000s with technology, this has only gotten worse. And so this was challenged oftentimes by technology. As we started to see the massive online education, we saw a lot of webinars and those kind of things. They wanted to be able to distribute information, but they were finding themselves struggling with the copyright laws. So the TEACH Act came out in 2001, which addressed digital delivery in the context of online learning. They gave them similar protections and had similar requirements, but they did allow for you to distribute stuff online so long as there was some protection associated with it. You couldn't just post it to a web space that was completely open to everybody in the world. It had to be underneath of some type of a protection, whether it was a login and password or those kind of things. So they had to have some reasonable technical measures to restrict further retention and distribution of that material. So sending via email somebody's copyrighted material to all of your students would not necessarily be protected under the TEACH Act, because that's material that they could then retain on their own computers and then redistribute from there. What's better to do is to host it on a web server that distributes it directly to view, but not to be able to be saved or something like that. Streaming video from your own server versus from distributing the work directly to the students is what's kind of the intent of the TEACH Act and what they tried to do to harmonize all of these different activities. Now the question comes about, well, what about our lectures? And again, this is the point of the discussion today. What are we doing with our lectures, and how are we distributing them to students, and are we giving away all of our work and hard effort? PowerPoint began in 1990. It came out in May 22nd, 1990 with Windows 3.0. It is, as of 2012, has 95% of the market share in terms of delivering content in a lecture like we are doing today. It's been installed on over 1 billion computers, and it's used, according to Wikipedia, a great valid source, 350 times per second. So it's quite ubiquitous, and that's the common format of how we give our lectures. That's just what we're used to. However, with the significant education expansion and distance education, we've started to see this material being distributed far and wide, and that's been some of the problems. Now, again, these are legal cases, are 2 examples and some legal cases that I won't get into directly, but these are starting to become common, and there's still 2 conflicting outcomes between 1969, the UCLA decision, and then 1996 with the University of Florida, where they came down on both sides of the issue in terms of whether or not students' notes could be seen as derivative copies of the lectures that were given and the copyright. There's 2 articles that I reference here, one with flashnotes.com that just recently came up with Florida State University. They take notes, and the students can sell them on this particular website for $20 a pop, and they can get money out of it. They actually just bought out 2 other similar sites. It started in Cleveland, moved to Cambridge. They've now acquired Note Utopia and Moolah Guides, and they are specifically trying to bring disruptive change to a world rooted in tradition. Now, what they call this is peer-to-peer learning. And what they are saying is that, well, we're just facilitating the learning that goes alongside with students. And they do have some copyright protection. I actually went to the site, I looked for lectures from my own students, but I didn't find any, which is good. And nothing underneath of the category of physician assistant either. But what I found was interesting was that they do suggest that anything that's copyrightable can be reported. But interestingly enough, it's a self-reported mechanism where they're not actively searching for copyrighted material. They're waiting for somebody to alert and whistleblow on it. So again, and Harvard Finals Club in 2007, a 2005 grad started this product. He's got a number of faculty members on board, and they're trying to make this the premier web portal for interactive education, and supposedly for the purpose of study groups. But they can study online, they can read annotated copies of great books. It actually paid students to post their lecture notes online, and ended up becoming more of a crutch for people who didn't want to go to class, unfortunately. So the American Association of University Professors actually looked at this a couple years ago, and even this summer came out with a committee meeting reference that suggests and reaffirmed these thoughts about lecture notes and those things. Their current position is that faculty scholarly work, which includes our lectures, is generally not for hire and should allow us to retain the copyright protection. Their statement this summer said that universities have often distinguished between copyrightable and patentable intellectual property, ceding faculty ownership to the former, okay, and asserting institutional ownership to the latter. But both are products of scholarship and protected by academic freedom, which provides for control by faculty authors of dissemination over their work. They actually suggest that faculty and administration should sit down and hammer out these ideas before it comes to a head and before they need the policies. They even suggest that they go so far as to say that syllabi, being a public document, are not as copyrightable as your actual lectures are. So syllabi are oftentimes shared between faculty and between courses, but they even suggest that faculty lectures or original audiovisual materials, unless specifically and voluntarily created as works made for hire, constitute faculty intellectual property. They cannot be revised, edited, supplemented, or incorporated into courses taught by others without the consent of the original creator. You cannot take, and according to their policy, you cannot take online content and just transfer it from one course director to another without actually going through the process of thinking through what's copyrighted and what's not, unless the faculty member wants to concede that to the other course director. And LegalZoom suggests that it's original as long as some measure of creative expression is included. And again, we're using material that's not our own, but we are presenting it in a way that's giving our own ideas and our own flair and perspective on it, and I think does fall underneath of copyrightable material. So what about student notes? What if a student takes notes from your lectures and says, well, this is my own derivative copy, and I'll do with it what I would like to because it transfers that protection to me? Again, if they're sufficiently original, then they have created a derivative work that is implied, authorized by the faculty. This comes from the University of Alabama's Office of Counsel. And so we don't want to impede them taking notes, which is what my lecture was on yesterday, but we want to make sure that they're not simply taking that material and running with it on their own in some fashion. At the same time, we don't want to be so stringent that if a student misses class, their student peers feel like they can't share their notes with their other colleagues, because that's not really promoting the ideas and ideals of our profession either. So we have to walk a fine balance and try to be careful with that. So let me give you a few different levels of policies and protection that we can institute that you might want to be thinking about, and just some conversation starters for you to have with your own faculty and at your own institutions. And it starts broadly at the institutional level and works all the way down to how we distribute the content of our lecture to our students, which is kind of what prompted me in this discovery. So from a general policy perspective, we need to have some institutional policy. What is the policy on copyrighted material, and what do we allow our students to do with the information that they have? Again, be proactive, because once you need it, it's probably already too late. And be consistent. As with any policy that we make at any institutional level, any accrediting agency is looking for consistency and that we're meeting our own policy standards. So it's not that there's one policy is necessarily better than another, it's just that at your institution, the policy needs to fit the environment and the culture, and then you need to be consistent with how you apply that policy. You may want to consider other policies as well that may have impact on the copyright. Do they come to class? Is there an attendance policy? Do you want your students to be able to just share the information, have one person come to class, have a one-on-one session with the professor, and share it with the rest of them in the class? Again, that's probably never going to happen, because fortunately most of our students, or I would hope that most of our students, are interested in the learning process because they want to learn. But how do we think about quizzes? Do we use quizzes as a way to encourage them to come to class? What's your recording policy on your particular lectures? Do you allow students to record you? Do you have an institutional policy on capturing your own lectures and distributing them for students later on? And do those carry over from one cohort to the next? Those kind of policies you need to be thinking through. And what about faculty relocation? When a faculty member leaves one institution, that's their copyrightable material. Do they just take all of it with them? Is there some professional courtesy that we have and obligation that we have to the institution where we were working that we would want to help them along with their lectures that we've created while we've been there? What will we do with that? And that's something that came up as a discussion point after I gave this talk last year. So here's a couple of examples of what some different places have done in their syllabus, where they've actually included a particular paragraph and section in their syllabus. This one from the University of Alabama: copyright such and such a year and your name, which is the typical way to identify a copyrightable material. As to this syllabus and all lectures, students are prohibited from selling or being paid for taking notes during this course to or by any person or commercial firm without the express written permissions of the professor teaching this course. UC Davis suggests that all federal and state copyright reserved for all original material presented in this course through any medium, including lecture or print. Individuals are prohibited from being paid for taking, selling, or otherwise transferring for value personal class notes made during this course to any entity without the express written permission of insert the author's name. In addition to legal sanctions, students found in violation of these prohibitions may be subject to the university disciplinary actions. Again, when we do our lecture prep, how we spend the time, we don't want to get into the habit of recycling everybody else's lecture, even though it might be easier. And certainly for a year where you've given a course that you're not particularly familiar with and may not have the time. But there are some ways that we can actually help give professional courtesy. And I would suggest that you maybe include in your lectures as you present new material or a material that's been created by somebody else, that you give professional courtesy to them and thank them. And I'll show you a slide example of that. In your actual lecture as well, there are ways to just include just some general things. One is to add a small little copyright symbol with the name, which I've typically done on my lectures, just as a way to remind students. It doesn't require that in order to maintain the copyright protection. You don't have to put that on there. The reason for doing it, though, is basically to remind them and to give them and to counter the argument that I just didn't know. So again, it's just one thing to do. It's not required, but it is beneficial. So this is one slide that I've created that I kind of use to just put in as a second slide of my lectures that I create, and it just says that this lecture, its content, and any derivative copies or recordings is provided for your personal study and use. This lecture is copyrighted and is not to be commercially distributed or reproduced without the express consent of the author. Now, my students kind of look at me odd, and I try to give them a little in as to why I do this. I've even had other faculty members like, is that part of our policy here? Do we have to do that? And I'm like, no. But this is just something that I've created just because I want to remind them as well. Here's the courtesy slide. Again, this presentation was adapted from presentations of two other professors that had previously taken over this course and had added to this particular lecture. And here's a third person that's building on that. And again, I just think that's a one way to give some professional courtesy to those that have done the work and the legwork beforehand, rather than just simply changing the name on it and reproducing it as your own. How do we distribute the lecture content? And this is really what was the impetus for my investigation into this. Again, I tend to be somebody who does not like to just give away PowerPoint content, and I do not distribute the PowerPoint lectures themselves. What I typically will do is distribute a PDF copy to my students. And the reason I do that was one, for formatting issues, to maintain the integrity of the formatting, but second of all, I want to try to make it somewhat difficult for them to actually take notes. And this was the purpose of my other lecture yesterday, which was basically to say that I don't want people to just copy and paste out of my slides into another document. I want them to be able to think through what they're writing down. And so this, though, is one way that I can protect some of the copyright and make it a little bit harder to justify them just simply stealing a slide out of it or something like that. And again, it speaks to my philosophy on note-taking, which I think is an important aspect of what we're teaching our students. There are advantages and disadvantages to both, but when you think through how you distribute your lecture content, these are some things that you have to think through. From the professor's side, I like to communicate critical information, and I will do so in a PowerPoint presentation or the notes below. But I also want to maintain their attention. I don't want to give away my slides so that 10 slides down they know the answer to the case that we're working through or the questions, the answers that we have. And again, I want to give some copyright protection. The students want to get the information but still be able to manipulate it and annotate it in a way that will help them understand it and remember it. But again, I don't want to just make it easy for them to steal that information. So when I compare the two, these are some advantages that I've come up with. With PowerPoint, it's simply easy to just take that same file you've been working on, once you clean it up and finalize it, post it to Blackboard, shoot it to your students, done. No more extra work. However, if you're trying to encourage their note-taking, you're going to have to do a lot more work behind the scenes to take out slides or to potentially remove information that you want them to remember. And that can add legwork to what you're doing. The disadvantages is, again, as we've been talking, you're not protecting your intellectual property as closely as you could. Whether or not you give the notes right up front or not, I tend to give my notes from my lectures after the fact. I'll give them the slides as a PDF in advance, but then I'll come back afterwards and give them the notes so that I don't want them to miss something or mishear what I've said or potentially maybe me misspeak what I was hoping to communicate, but it's important. The other disadvantage, again, is not being able to hide slides or answers without doing some extra additional work. And there's no native audience response system within PowerPoint. There are third-party options available, but they tend to be a little bit more of a challenge. With the Adobe portion, it's simple to, within Microsoft, just to quickly publish as or save as a PDF. It's a fairly quick transition to get that into the PDF format. There's universal formatting and a little bit of IP protection, at least one more step. If they have Adobe Pro or something like that, it's easy to reconvert back, but again, it's still one more step. And I always get a lot of student complaints every time I give out my PDF versions because they, again, are into the habit of transferring the information from a slide into a Word document, and all they're doing is really reformatting it, not taking notes. And again, that goes back to my philosophy on note-taking. So here again is another statement coming out from the University of Alabama and the reference document that I had from them, just suggesting that this is one way that you can start off your class. Now this might get a little boring after a while. Maybe you just want to have a recording that you hit every time. This might be a little overkill, but it says, this particular professor started off saying, "My lectures are protected by state common law and federal copyright law. They are my own original expressions and I record them at the same time as I deliver them in order to secure that protection. Whereas you are authorized to take notes in class, thereby creating a derivative work from my lecture, the authorization extends only to making one set of notes for you, for your own personal use and no other use. You are not authorized to record my lectures, to provide your notes to anyone else, or to make any commercial use of them without express prior permission from me." Again, this doesn't help address the student that misses class that for a legitimate reason. And so again, we don't want to be too rigid, but at the same time, we want to at least alert them to the possibility of the lecture copyright issues. So again, other considerations that you might have, we don't record lectures at EVMS where we are, and again, part of that is because you're on record as soon as you say something. And again, this is another policy that you want to have. Do you allow your students to record you? I've had a number of cases where the students come back and say, "You said," and they're, with the ubiquitous nature of laptops, iPhones, pens that actually record audio, you are on record whether you realize it or not, okay? Your students are pretty savvy, and I've seen a number of them recording things. And again, we have to be careful. And again, if we're not explicitly addressing it within our policies, I can imagine and I can only assure you that they're recording you. Video recordings, again, some students or some professors are camera shy. They don't like the fact that they're on camera. They're not used to the fact that they might be on camera. So again, you might want to consider having an opt-in policy versus an opt-out policy, allowing students. Again, do we want to give them the option to review audio recordings and video recordings? It might be worthwhile. There are some students who need that second pass effect in order to get that information. But again, it's just one thing. Part of my talk discussed something called lecture tools, which came out of the University of Michigan. I won't go into too much depth today, but this is one particular platform that does a number of these things all at once. It allows for audio response. It allows for you to hide slides on the go and reveal them at your discretion. It allows you to do some copyright protection, because when you upload your slides, it's not an actual slide, it's a JPEG of your slide. And so it makes it much more, it makes it easy for you to get the copyright protection. It also gives the students an option to take notes digitally, typing, which, as I discussed yesterday, is probably not maybe the best, but is certainly better, to combine those two together. It's a nice little platform, and I think there's some advantages to it. I won't go into too much more depth, but I would encourage you to look at it, as it does have some benefits along with what we've been talking about. So there are some critics out there as to the copyright issue. I know Tim Woods did a great job talking about this yesterday with common Creative Commons lecture material from Image's standpoint. But there are critics out there. They'll say that it's an ambiguous term, that in reality you can't identify intellectual property. And his opinion is that you've taken four discrete things: trademarks, patents, intellectual copyright, and amassed them underneath of one bill that just doesn't do justice to the variety of things that happen underneath of each one of those terms. It's a catch-all to lump together all these disparate laws, and it really doesn't work well. And so again, there are critics out there that say, well, maybe the ideas in and of themselves are not really physical property. As a matter of fact, Thomas Jefferson had this idea. He said in 1813, if nature has made any one thing less susceptible than all others of exclusive property, it is the action of the thinking power called an idea, which an individual may exclusively possess as long as he keeps it to himself. But the moment that it is divulged, it forces itself into the possession of everyone, and the receiver cannot dispossess himself of it. Its peculiar character, too, is that no one possesses the less of the item, because every other possesses the whole of the idea. He who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper at mine receives light without darkening me. So Thomas Jefferson's idea was that really we're not losing anything by sharing this information or giving it to them, which is why Copyleft, Creative Commons, and others have attempted to use the copyright laws to their own means, which basically just suggests that, well, let's at least give ability for people to use this material, but as long as they give me the attribution of creating it. Goes back to the common courtesy slide that I mentioned before. Copyleft is the practice of using copyright law to offer the right to distribute copies and modified versions of work, and requiring that the same rights that you apply to it be preserved in modified versions of the work. So again, they're trying to make it as free and accessible as often as possible. You'll notice that Copyright is for Losers has already been trademarked and copyrighted by the individual who painted that, which is interesting. Now, some open source education has put this to the test as well, with MOOCs, as well as FOAM, which is free online access, open access to medicine. But again, we'll see how that goes in the future. So even at Eastern Virginia Medical School, we have one policy that covers both intellectual property and copyright. It's 14 pages long, 4.5 pages of which deal with just copyright. And again, the good news is, at least for our particular institution, the way that they have defined it is that the faculty member of a traditional non-directed work owns the copyright of the work unless it is involving some exceptional use of EVMS resources. This would be creating something that requires more than the resources that you're normally allotted. It's access to audiovisual recording, excessive time and effort from other departments within the institution. However, they also suggest that as a condition of employment, each faculty member creator of a traditional non-directed work shall be deemed to have granted EVMS a non-exclusive, non-transferable, royalty-free license to use and to permit others to use the work for EVMS's own educational and research purposes, unless such a license would impede the scholarly publication or similar activities. And so, again, my suggestion to you at this point is to check your own employment agreement. Find out what it is that your employers have already put into place, whether you're aware of it or not, and find out what restrictions have been placed on your students and what are they doing and with the information that you're providing for them. Ask legal for any opinion that you might need. And again, discuss with your program faculty. Are there any other things that you guys need to be doing? Should the policy be program-wide, and should you be giving, should everybody be doing the same thing from a faculty standpoint? Again, configure your policies, syllabus, and lectures according to your ideas of what you want to communicate to your students, but inform your students of what your policy is and why you do it, and again, forcing them, helping them to understand. And you may even consider publishing your information instead of copyright. This came to me recently. Why not publish your information under Creative Commons? As long as you're getting the credit for what you're doing, maybe it's not such a bad idea that we give our information to our students. But again, it goes back to your philosophy on note-taking and whether or not you think that giving them easy access to copy and paste is a good thing or not, which again was a different talk. So in the end, I would say it's all about balance. It's the weighing the needs of your students, the need of you as a faculty member to protect your time and effort involved in fixing those lectures into some medium that is copyrightable or not. Again, there are some resources for you. A couple of things. The American Association of University Professors has a great website in terms of access to information on these topics. Again, Tomorrow's Professor comes out of Stanford. That's a great resource. It gives you sometimes twice a week emails that digest important information out of the literature. And the update to the American Academy of University Professors came through there, and it's great. And again, Lecture Tools is one medium of ways to actually protect your information and maybe worth your consideration as you think through it. But again, I have no financial obligation to them or they to me. So with that, I think we have a few minutes for questions. If anybody has any questions for me, or you're ready to wake up and move on. Yes?
In a previous position, I was active on the Senate and the Executive Council for a liberal arts university, which had a PA program. And of interest to me was how many faculty across the campus never really gave copyright a thought until they maybe left or had an adverse consequence that they felt they needed to protect themselves. And so we attempted to try and bring this forward to have the administration pass a rule, create a policy where none existed.
Right.
And one of the things that tripped up the process was that there was an insistence on combining copyright policy with patent policy.
Yes.
Because there was a whole science department
Correct.
that was actually receiving NIH grants and so forth. So my suggestion to you is, if you are interested in looking into this and it's something new, try hard to see if people can separate the patent issue from the copyright. Because patent really affects a much smaller percentage of faculty than copyright does.
And that's a good point. Even in our policy, it's a combined policy on intellectual property. But again, it's divided into those different research components and the copyright issue. And as I mentioned, 4.5 pages is just a specific section given over to copyright. So it falls underneath of the same policy. But again, because those are two separate entities under intellectual property in terms of patents and research findings, it is certainly something to tease out. But as you mentioned, it's usually never given a thought because we never think that it'll happen to us, or when you go to leave or something like that. Any other thoughts? Yes, ma'am.
You use a central repository at your institution, like a Blackboard or something like that, to post materials. We were told that once it's posted there, it's university property.
And again, that might be the university where you are, their position on that information. The AAUP would probably come back and saying the lecture material itself is yours and it's your copyrighted material. The syllabus tends to get published on a public forum. If you can pretty much go to any university and search for their syllabi and oftentimes come up with it, but that tends to be, according to the AAUP, more of a non-copyrightable, but the lecture material they suggest should be yours and yours alone. Because it's in a protected format in Blackboard with only access to those who have either enrolled in the course or who have access with passwords, that doesn't necessarily mean you lose the copyright protection from it. That's just making sure that it doesn't go beyond the borders of your school. But that's something I would take up with and look at the documentation from your institution and actually assess. Any other comments or questions? Well, thanks for staying with me on a dry topic, and I hope it's encouraged you to think through some things as well. Thank you.
You mentioned you'd make the PDF available after the
I will be happy to send you the PDF, okay? Sound just like my students. Feel free to email me and I will get it to you, no problem. You're welcome.